Hello, everyone who is attending this webinar. For those who do not recognise my voice, my name is Jim Thurston, and I am the President-elect of the Society for Radiological Protection. And I'd like to welcome you to this seminar on how to read legislation. This webinar is in partnership with AURPO. We have had a fantastic response to our program, and the program is developing, and we are looking forward to having more of these webinars in future. And as you will see, we have well over 200 attendees for this particular webinar. To register your attendance at this webinar and to therefore get your CPD proof, as it were, if you go to the question and answer tab, you will see that there is a code that you need to email to Charlene at SRP, and the email address is there, and that in that way you will then get your proof of attendance. Okay, there are a few ground rules, of course, for running these webinars to help them run smoothly. And the first thing is that you will be able to ask questions through that Q&A box. If you write your question into that Q&A box, we will look at those questions which are, say, most liked, and those will be answered at the end of the presentation. But we will also try to address those that are not answered at the webinar using the past events page on the SRP website. So I would also invite you to send us your feedback at the end of the webinar. You can email that using an online survey link, which will be available after the webinar. It'll be very useful for us to see how this event has gone and to make sure that we learn from it and make them better in the future. We certainly do intend to run more of these in future. We are indeed having to run all our SRP events virtually at the moment, and so for example, the next conference, the Southwest Conference, which was due to be run face-to-face on the 7th and 8th of October, is now going to be a virtual event over those 2 days. Equally, the Recovery and Remediation one-day event on the 11th of November is now going to be a virtual all-day event. And as you can see there, we do intend to have more of these one-hour webinars, and that we're lining those up, so look out for those. If you have any suggestions for further webinars, please do get in contact, email admin at the SRP, and we'll see what we can do about including those or adding those to our program. So without further ado, I would like to introduce to you Pete Cole from AURPO. He's the current president of AURPO. And he is a past president of SRP, and he's in a very good position, therefore, to introduce our speaker and say a few words for you. Thank you.
Thank you, Jim. I hope everybody can hear me okay. I've had a little bit of sound trouble in the last few seconds, but welcome everyone to the latest webinar in this series of free online training webinars brought to you, I'm pleased to say, by a collaboration between AURPO and SRP. As Jim just intimated, I think these webinars have been a tremendous endeavour, not only assisting the training needs of our members, both our respective memberships in these difficult times, but also supporting the wider radiation protection community and promoting both national and international knowledge exchange. So without any further ado, I'll introduce today's speaker, who's a good friend and colleague of mine for many years, and over many years we've worked on several projects together, some of them rather difficult. So Dr. Chris Englefield, trained in health physics in the defence nuclear industry, and then had over 30 years working for the regulator, the Environment Agency. He is now semi-retired, but operates an international consultancy to organisations, governments and universities around the world. This webinar is based on a number of lectures previously developed for teaching radiation protection at undergraduate level. And so today, Chris is going to tell us how to read the legislation. Over to you, Chris.
Thanks, Pete. Before I start, let me just say welcome to the webinar. Thank you for signing up, and thanks to my SRP colleagues for their introductory remarks. A few words of introduction. Many of you will know I'm not a lawyer, so in any formal sense, I'm arguably not qualified to deliver this webinar. But if you're listening to this, you must have decided there's some point to it. So I do wonder what that point might be. Well, what I can say is, for me, the point is that expecting someone, even someone who's used to developing themselves, you know, at graduate level, for example, to read and understand and navigate around a piece of legislation without training and support is a bit like giving someone an ordnance survey map without a key attached and no opportunity to learn and practice map reading. Very soon, they're going to get lost. The Environmental Permitting Regulations 2016, for example, are 292 pages long and include 29 schedules. It's not a 5-minute job to read through, should you need to. But what about if you understood the lie of the land and knew, because you'd been properly trained and gained experience, that's really important, that there are large parts that you can essentially, for example, safely disregard if you only work with radioactive substances? Would that be helpful? I think it might. I hope also that the point is that you expect that at the end of this session, you will be a little better able to find your way around legislation in the UK, that you will be better able to understand what it says and, equally importantly, actually what it does not say, and how to find out more. And I also hope that you will find that you are better equipped to ask appropriate questions of lawyers, whether you're a regulator or an operator. I'm very aware that not everyone listening is subject to environmental legislation. Many, perhaps most of you, will have more interest in the legislation enforced by the Health and Safety Executive or the Office for Nuclear Regulation. This webinar is not going to look at the details of any of those, and I'll try, as best as I can, to use wider examples than the law that I used to regulate under. Moreover, UK law has 3 historical components: English law, Scots law, Northern Ireland law, and, well, since 2007, actually a 4th, Welsh law that's been passed by the Welsh Assembly. In addition, clearly SRP and AURPO have members from all parts of the UK, as well as other countries, and so it's not appropriate to focus, for example, just on English law. What the webinar will try to do, therefore, is to look at principles that can be applied to any type of legislation in a common law state. That should be broadly relevant in any Commonwealth of Nations country. I hope this approach will broaden the audience for this webinar when it's offline and be seen as a realistic approach given the fairly severe time constraint. So I'd like to begin by briefly establishing my credentials for presenting this webinar. As you've heard, after qualifying and practicing in radiation protection for the defence nuclear industry, I became a regulator. The UK's regulatory body, I'm sure you're well aware, is multifaceted and complex for historical reasons. I worked for the Environment Agency and its predecessor organisation, whose role includes to regulate the keeping and use of radioactive substances and the accumulation and disposal of radioactive waste in England. You will appreciate that regulation involves implementing legislation, especially in my context that is intended to provide environmental protection. The latter part of my career drew me into other areas such as counterterrorism and security, and so to a greater or lesser extent I was working with a wider range of legislation, including things which, for example, regulated covert surveillance by the regulatory body. I retired from public service in 2014 and established and maintained this consultancy, as you've heard, on regulatory matters and nuclear security. In this capacity, I've been training for nearly 7 years, and I've taught in many higher education establishments around the world. I'm also a visiting research fellow in the Centre for Science and Security Studies at King's College in London. When I was doing a proper job, I was very fortunate to be trained by other regulators who had spent many years not only implementing legislation, but also drafting it. This was in the early days of the Pollution Inspectorate, which was then part of the Civil Service. I recall in particular my good friend, the late Dr. Clive Williams, FSRP, amongst whose many drafting achievements is included the then named Litvinenko exemption order. More formally, this was a so-called statutory instrument known as the Radioactive Substances Emergency Exemption England and Wales Order 2006 number 3169. So if you're interested in this rather esoteric piece of legislation, which is no longer enforced, this is provided in the references that are in the transcripts, which will be made available to you later. And its purpose is explained there as well. The reason for mentioning it is that I will be going back to explain some of the terms in that rather complex title in a little while. I think I can hear some of you saying he's stuck in the past, he's not giving us anything useful. I guess you could be right, but please bear with me. I hope I can change your mind about that. Now I'm going to change my slide. However, it doesn't want to work. Sorry about this. When I try to change slides, nothing is happening. Let's try now. There we go. So working as a regulator caused me to interact with a wide range of issues and a very wide range of people. Some of these would quite often ring me for advice on regulatory matters, for example, on what a particular clause or regulation meant for them. Very often, these people surprised me with their lack of insight into the structure and operation of the law. On one especially memorable occasion, someone who I considered to be the best RPA and RWA in the country called me and said, I want to do X, but the regulations don't say I can. What can I do about that? So I explained that not having a specific permission in law did not mean that something could not be done. I won't name that caller as I don't want to embarrass her. But as a result of experiences like this, I introduced a lecture very much like this webinar into the BSc in Radiological Protection at Cumbria University. This was run by our own Alan Marsh, who is also sadly deceased. And it did seem to be well received. So this webinar is only 45 minutes long, and I can't make you a lawyer in that time, and even if I was qualified to do so. However, if I can spark just a little bit of interest in these matters in someone who was not previously aware, then, well, I'll be satisfied. It'd be great to think that such a person went on to study these things in a bit more detail as part of their professional development. In the time that's available, I can only explain a few things. I'd like to give you some indication of why all this matters, but also I need to give you an insight into what the components are of the UK legal system, so-called common law and statute law. I'd also like to talk about the main types of legislation, known as primary and secondary, and the structure of legislation, in the hope that you'll find it easier to find things therein that matter to you. And we'll also look at some of the conventions that are used by the people who've drafted that legislation. Inevitably, I have to talk about the way European legislation has been implemented in the UK, but clearly and sadly, there is no point in spending a lot of time on this, but there are some points of more lasting interest. And finally, what I want to do is to point you to other sources of information. Before I conclude this rather lengthy introduction, I'd like to say one more thing. It may be obvious to many, but it's still worth saying the law is about words and language. If you've got no interest or get no satisfaction in the precise and consistent use of words to convey ideas, then understanding legislation and this webinar are really not for you. but the precise and consistent use of words to convey ideas is what the law does. You don't have to be a language anorak to understand how the law works, but it does help to understand the law if you work in radiation protection. So, why does knowing how to read legislation matter? Well, the interpretation in the formal sense of legislation is a job for lawyers and especially the courts. In their literal final analysis, it is what judges do. We clearly can't and should not aspire to the same level of competence nor power. But as professionals, and particularly those of you who are advisors, your role is to make a sincere and reasonable attempt to advise your employers and to understand, or maybe sometimes even challenge, what regulators are telling you. This may include, for example, during application for permissions or authorizations, during compliance phase and during changes in compliance, such as when moving into decommissioning, or perhaps in the event of enforcement action. In addition, the time may come when you have to interact with your own organisation's lawyers. I hope that you will find that you're better equipped to ask appropriate questions of them after you consolidate what I'm saying today. But there is another thing, and this is the reason why SRP and AURPO are offering this webinar. In our field, radiation protection in the broadest sense, being able to develop the ability to read and gain a practical understanding of legislation is a professional skill. I would argue that at least regulators and advisors should consider it a professional duty to develop themselves in this way. I'm not sure yet how it could be assessed, but it seems to me that SRP and AURPO should be expecting their professionals to acquire this skill, certainly by the time that the level of chartered status is achieved. To embark on this process of development, one first needs some knowledge, and I hope I'll provide your first tranche of this, followed by practice. Then, all you need to do is more practice, followed by more practice. Eventually, you will find that you're confident you've cracked it. That's the plan. So let's talk about the UK's legal system, and in particular, I'll start with common law. The basis for the UK's legal system, common law, is so called because it's been common to all persons since around, well, 1066. This, you may recall, is when the Normans invaded Britain, and yet it was the initiator of a particularly British approach to a legal system, different even from the modern French system. English common law is not written down as legislation, but represents a legal system based upon precedent. This is centuries of case law largely based on Judeo-Christian values. For example, there's no specific piece of law about murder. Murder is an offence under common law in England and Wales. The crime of murder is committed where a person of sound mind, they're sane, unlawfully kills, it's not self-defence or some other justified form of killing, any reasonable creature, a human, in being, which means alive and breathing, under the Queen's peace, i.e. not in wartime, with intent to kill or cause grievous bodily harm. No law, no written law is involved in that. In continental Europe and in many nations outside the British Commonwealth, the Code Napoleon, or the Napoleonic Code, is the basis for governing laws. The key difference between these two systems is that common law is a bottom-up legal system that implies what is not forbidden is permitted. In other words, common law defines what you can't do while leaving you free to do everything else, while the Napoleonic Code is seen by some to be a top-down system that often becomes more bureaucratic and controlling in its approach to governing of citizens, effectively spelling out in more detail what you can do under a government knows best mantra. But common law is not the entirety of our system. Let's now consider statute law. The first English Parliament was convened in 1215, and with the creation and signing of the Magna Carta, which established the rights of barons, who are wealthy landowners, to consult to the king on governmental matters in his Great Council. We've come on a bit since then, arguably at least, but Britain did not become a democracy until the Representation of the People Act of 1918 and the Equal Franchise Act of 1928. These gave the vote to all men and women over the age of 21. We now take it for granted that one of the main tasks of Parliament is to make law. To distinguish it from the older common law, this is known as statute law. Common law and statute law sit hand in hand in our legal system. By the way, the other tasks of Parliament, and we'll come back to some of these, are representation, acting on behalf of voters and citizens, and scrutiny, examining the government, and of course the formation of government. We live in a parliamentary democracy under a constitutional monarchy in which the monarch is the head of state while the Prime Minister is the head of government. Executive power is exercised by the British government on behalf of and by consent of the monarch, and the devolved governments of Scotland and Wales and Northern Ireland, the Northern Ireland Executive. Legislative power is vested in the two chambers of the Parliament of the United Kingdom, the House of Commons and the Lords, as well as in the Scottish and Welsh Parliaments and the Northern Ireland Assembly. A very important principle is that the judiciary is independent of the executive and the legislature. So to summarise, common law and statute comprise the key pillars of law in the United Kingdom. Let's now look at how the legislation actually works. So we're going to be talking about primary and secondary legislation in the UK. You may have heard lawyers talk about primary and secondary legislation, so I thought it would be useful to understand what these terms mean. Primary legislation is the term used to describe the main laws passed by the legislative bodies of the UK. For example, acts of the UK Parliament, the Scottish Parliament, the Welsh Parliament and the Northern Ireland Assembly. And it also includes other things like acts passed by historical parliaments or other primary legislation, including legislation for the establishing church in England, which has been passed by the General Synod. These types of legislation are sometimes referred to as statutes, and the term statute book refers to the whole of the statute law currently in force. Although a so-called green paper is used for initial consultation by government to inspire discussion on the potential need for legislation, statutes start life as bills introduced to Parliament in the form of a draft Act of Parliament that is proposed should be enacted to make new law and or to consolidate, amend or repeal existing law. A bill's sole reason for existence is to change the law. Somebody eminent once said, it's not there to explain, to entertain, or to perform any other useful functions of literature. The resulting act is the law, but only after debate and scrutiny by Parliament. Primary legislation, acts, are numbered chronologically within the year to which they are enacted, and the numbering restarts each year. For general legislation in the UK, the number is referred to as a chapter. Acts are therefore usually cited by their type, year and chapter number. For example, the Data Protection Act 2018 is cited as 2018 Chapter 12. Certain items of legislation are still made by the Crown and the Privy Council under the royal prerogative. These are called prerogative orders, and they're also referred to as primary legislation. An example that I thought might be relevant is the granting of a royal charter. You'll probably be aware that SRP holds the Royal Charter for Radiological Protection in the UK. Its effect is to recognise and incorporate the organisation. Incorporation by charter is a way of acquiring legal personality and reflects the high status of that body. The authority for the grant of a charter comes from the royal prerogative. That is to say, the grant is made by the sovereign on the advice of the Privy Council. An institution incorporated by charter is subject to the general law, but it's generally self-regulating and not answerable to anyone else in relation to the conduct of its internal affairs. So you can see why chartered status via the Radiation Protection Council is an important professional goal, whichever professional society for radiological protection you belong to. In summary, for our purposes, primary legislation, that term means acts. Let's move on to secondary legislation. Secondary legislation is also sometimes called subordinate legislation, and it's what's called delegated. It's delegated legislation made by a person or body under authority contained in primary legislation. Typically, powers to make secondary legislation are conferred on ministers or the Crown or on public bodies. In other words, they're not subject to the same level of parliamentary scrutiny as primary legislation. For some secondary legislation, no parliamentary involvement is required at all. Some secondary legislation is sometimes made when a draft is signed into law by the person with statutory authority to do so, which is often the Secretary of State for the relevant government department. The nature of secondary legislation, therefore, means that unlike primary legislation, it can be invalid, or the technical term is ultra vires, where it goes beyond what is permitted by the parent legislation or the wider law, such things as the Human Rights Act 1998, or where it's not passed in accordance with a required procedure. A general example of delegated authority to make a statutory instrument is that the Office of Communications, Ofcom, is given powers to make its own legislation by the Communications Act of 2003. There are three main types of UK statutory instruments, this secondary legislation: orders, regulations, and rules. However, there is no limit imposed on the description that may be given to statutory instruments, so you'll hear things like scheme, direction, declaration. All these different types of instruments, as they're called, serve different functions, but they all have the same legislative force. Even church instruments, which are made by the Archbishops of Canterbury and York for church matters, have the same legislative force. So, statutory instruments in the UK are numbered sequentially each year. Welsh statutory instruments and orders made under the Northern Ireland Acts are included in the same numbering system as UK statutory instruments. Examples of numbering of statutory instruments in the UK from the UK Parliament include 2017 number 1075, Health and Safety, the Ionising Radiations Regulations 2017. You might remember that one. And also 2016 number 1154, Environmental Protection England and Wales, the Environmental Permitting England and Wales Regulations 2016. So there are minor differences relating to Wales and Scotland and the Northern Ireland Assembly, or the Senedd Cymru, its new name, but I won't go into too much detail there. In my view, the main statutory instruments, known as SIs, that we are likely to encounter in our field are regulations and occasionally directions. As well as making new law under a host of UK parent statutes, regulations are also the method used to transpose or implement EU directives into English law. But not now. Just for completeness, until Brexit, EU regulations, as opposed to directives, were directly implemented in the UK under provisions of the European Communities Act. So let's look at a radiation protection example of regulations. In the Ionising Radiations Regulations 2017, there's a paragraph that follows the list of schedules on page 3. And I've paraphrased slightly for clarity, and don't worry, I'm not going to read this all out. But what you see there is that the Secretary of State makes these regulations this example of secondary or subordinate legislation in exercise of the powers conferred on him by all those sections under the Health and Safety at Work Act of 1974. So in summary, the ionising radiations regulations are said to be made under the Health and Safety at Work Act. Now, the Litvinenko statutory instrument that I referred to at the start was an exemption order, but the exemption regimes of England, Wales and Scotland don't use that term nowadays, but in Northern Ireland, where the Radioactive Substances Act is still in force, they do. Exemptions in Northern Ireland are implemented by the Radioactive Substances Exemption Northern Ireland Order of 2011. Exemption arrangements in England and Wales are provided by environmental permitting regulations of 2016, as it is now. An important point to note about exemptions is they're not exemptions from the law, but exemptions under the law. Hence, many of them have limits and conditions which must still be complied with. As a dyed-in-the-wool regulator, it always frustrated me when I was working for the regulator that in England we never knew which premises were operating under exemption provisions. This meant we could never assess compliance. This mattered, in my view, to operators because there was no graded approach to enforcement. If you were not complying with the requirements of the exemption order, all you could do as a regulator was prosecute. I tried to argue to change this with policy colleagues when potential opportunities arose, but I couldn't win that discussion. I understand that Scotland has now adapted an IEA style notification arrangement. Good for them. It sounds much more like it, and at least they have the data, even if they don't necessarily have the resources to assess compliance. It seems more logical to me. Before moving on to briefly discuss the status of guidance in the radiation protection legal system, I'd just like to mention that the vocabulary we use in the UK profession for radiation protection is different to that used in Vienna by the IEA. We'll come back to the IEA in a little while. I've spent a year of my life in Vienna at the IEA, albeit just a week at a time, and it still takes me a day or two to replace my UK lexicon with my dusty IEA lexicon. It's like changing from Ordnance Survey maps to Michelin maps. It takes a while to adopt a new mindset. So I'll move on to talking about guidance. Guidance represents an aid to interpretation of the legislation, but it doesn't have the full force of the law. So there's a hierarchy of legislation and guidance. To use the environmental permitting guidance as an example, it sets out how the various provisions in the legislation have been determined and how each provision in some way supports the application of risk-informed regulation. Although guidance is often intended to be standalone, there are circumstances where the legislation needs to be consulted for a strict legal interpretation. Guidance cannot cover every particular situation. In the case of any doubt, interested parties should refer to the legislation itself. You need to be able to find what you're looking for. You need to understand the language. It might be that it would this would be particularly helpful should there be, for example, enforcement action. Where the offences, it's worth pointing out, are under the legislation. So the guidance might be considered, but it's the legislation that really matters. And the legislation these days is usually regulations. So it's the regulations that an offender would be tried against. So there's a limit to how much reliance should and could be put on guidance. So let's look at this hierarchy that I referred to a moment ago. There's three levels: the legislation, which sets out the legal provisions described by Parliament, which deal with the scope of the legislation and perhaps any, for example, any requirements, exemption from requirements for a permit, to use the environmental permitting regulations guidance as an example. Government guidance sets out the expectations of the UK government and the devolved administrations with regard to the legislation. It's written primarily for the use by regulators, but it'll also assist those who are subject to the legislation. And then the regulators produce very good guidance themselves, which set out procedural matters in detail. And it has more detailed explanations of how the legislation applies to particular industrial sectors. An example here is the approved code of practice under the ionising radiations regulations, which set out the minimum legal duties, and the approved code of practice text and guidance gives practical advice on how to comply with those regulations. To illustrate the relationships between the three levels of the hierarchy, we can take from the environmental permitting regulations the example of an exemption relating to record keeping. The legislation states that adequate records of waste disposals must be kept. The government guidance sets out the purpose of record keeping and explains why different types of record may be required. And the regulator's guidance sets out the procedural issues related to record keeping. Just in case you don't know already, texts of most Acts of Parliament, as originally passed by Parliament since about 1800, I think, are available on the legislation.gov.uk website. There's a link there and it's in this transcript. You probably appreciate that case law is not held on that website. These days, as I say, the environment agencies and the HSE provide very good quality guidance to operators, and this can be found at their relevant websites, three of which are listed in this transcript of this seminar, and they're briefly on screen here. The intention and the achievement of this guidance is to be helpful to operators, but I would just caution you to remember that it's the legislation which is the overarching and important document. When Pete Cole asked me if I'd do this webinar, he sent me a list of suggested subjects, and I will have been addressing many of those, but not all of them. There just isn't time. One of the things he suggested was, where does the drive for law on radiation come from? Euratom, IEA, ICRP? It's difficult to answer this more briefly than saying yes, but I'll try and explain that. ICRP, clearly a very competent and highly eminent but self-appointed body, influences IEA, which is the relevant policy-making agency of the United Nations. So output from the IEA is available to all United Nations member states and indeed normally to others. So the agency was set up as the world's Atoms for Peace organization within the United Nations family. From the beginning, it was given the mandate to work with its member states and multiple partners worldwide to promote safe and secure, peaceful nuclear technologies. This includes issues of radiation protection. The objectives of the IEA's dual mission to promote and control the atom is defined in Article 2 of the IEA statute. Now, this is a confusing term in the context of this webinar. Just think of it as an international treaty. A treaty is a formal and binding agreement entered into voluntarily by sovereign states under international law. Treaties can be loosely compared to contracts in that the parties willingly assume binding obligations among themselves. In our context, this is in the nuclear field. So states which have signed the IEA treaty agree to collaborate. And they offer their joint findings to member states and non-members, and the content is regarded as significant in the European Union. And it's long been an influence on thinking and policy development in the European Commission, the European Parliament. And at the moment, that's the route by which we have acquired all our relevant legislation on radiation protection. So member states of the European Union thus have the outputs from the Commission and the Parliament, as it were, thrust upon them, but this is what they signed up for. European directives are transposed into national law by the respective governments of member states after a national policy making process, and European regulations get direct implementation. There's no need for further legislation. So if you compare the IEA's international basic safety standards with the European Union's basic safety standards directive, they're almost identical, though this hasn't always been the case. While it was a member state, the UK government had used the directive as a policy framework and had ensured UK compliance. And at the highest level, this has ensured an essentially common approach to radiation protection across what is now 27 states of the European Union plus the UK, under the Euratom Treaty, as it's known. It's worth pointing out that although the IEA has no regulatory role with regard to radiation safety, though it does for safeguarding of nuclear material, European directives have the force of law, had the force of law in the UK, but only once they were put through this process of transposition into UK legislation. Clearly, at the moment, the UK remains closely aligned to the European Basic Safety Standards Directive. So I'd just like to illustrate a brief example of how the influences on the law of radiation protection came about. Some years ago, the IEA sought advice from ICRP on the dose threshold for exposures of the eye. Later, the ICRP advised reduction in the threshold and other changes. This was then included in the IEA's general safety requirements, which was introduced in July in 2014, and the same changes were simultaneously included in the revised Basic Safety Standards Directive of the European Union, the 2013 Directive 59, protecting against ionizing radiation. So you'll probably be well aware the equivalent dose limit for the lens of the eye for occupational exposure in planned exposure situations was reduced from 150 millisieverts per year to 20 millisieverts per year, averaged over defined periods of 5 years. So this reduction in the dose limit for the lens of the eye followed the recommendation of ICRP in its statement on tissue reactions. Now, you may recall that SRP challenged both ICRP and IEA on this change on the basis of lack of notice and its prematurity compared to the availability of technologies to assess compliance. Now, the important point and the reason for mentioning this is to convey the international nature of the drive for laws on regulation relating to radiation protection and the influence of bodies like ICRP and others on the International Atomic Energy Agency, which is itself an influence on multinational or national policy and legislation making bodies. As a result of all these changes, the change in the iDose threshold was incorporated into the ionizing radiations regulations of 2017. Now, I can see that time is running fast, so let's return to UK legislation and start to look at some of the fine details that influence our ability to read legislation. In other words, the structure of an act and of a statutory instrument. And I've chosen to use two examples: the Pollution Prevention and Control Act, which is the primary legislation for the environmental permitting regulations, and the ionizing radiations regulations as an example of secondary legislation. So here's an image of the front page of the Pollution Prevention and Control Act. So first of all, notice the short title. I've just used it, the Pollution Prevention and Control Act. Then notice the year of its enactment and the chapter number, so 1999, chapter 24. Below that comes the long title, which explains the purpose of the Act. An Act to make provision for implementing Council Directive 96/61 EC and for otherwise preventing and controlling pollution, etc., etc. Then note the date of royal assent, which is when the Queen agreed it should become part of the statute book. Prior to that date, both Houses of Parliament must have agreed the final text of the bill before it could be signed off by the monarch and become an Act of Parliament. Just be aware that this is not the date at which it becomes law. We'll get to that very shortly. Then further down, we have what's known as the body of the Act, the meaty bit. Deep within the body, you'll find a commencement section that tells you when it came into force and may include a pointer to where, if you're interested, you can find details of the previous legislation that the latest one amends. There's also likely to be a pointer to the location of transitional provisions, how the changes will be introduced over an initial period of time. In this example, the same section includes some aspects of interpretation, some definitions. You'll also find this these definitions sometimes in other parts of the Act. This is definitely, in the interpretation section, is definitely a section not to forget about, because you should be referring to it almost every time you read the piece of legislation. It's the definitions within the legislation that matter in the first instance, not the definitions that you might ordinarily assume from their use in common parlance. Eventually, you get to the schedules. The schedules of an Act can be thought of as an annex of additional information that does not sit well in the body of the Act. Note that although it's not part of the body of the Act, it does have the status of part of the law. In the Pollution Prevention and Control Act of 1999, there are just 2 schedules. Now, the structure of secondary legislation is in many ways very similar. So we're talking about regulations, and this is the example. You'll see a similar sort of layout. So really the things I want to highlight here are the chapter number of primary legislation is replaced by an SI number. And actually also there's a very useful contents page in regulations, and this really does help you navigate through a substantial set of provisions very quickly. We all know what a contents page is. It summarises the content, and if you refer to those contents frequently enough, it soon becomes very familiar to you, and this will speed up accessing the parts of interest to you. Note that statutory instruments, and especially regulations, often have many more schedules than their parent primary legislation. In the ionising radiations regulations, there are 9 schedules, some of which are further subdivided into parts. In EPR 2016, there are 29 schedules. Only schedule 23 is likely to be of interest to radiation protection professionals. So finally, we get to the key question. How do you read legislation? And the answer is carefully, very carefully. It requires concentration and a concentration span. Speed reading is definitely not recommended. Skipping words is highly likely to create a misunderstanding of the intent of the part you're reading. Every word, every comma, and each line adds something to the precise and consistent narrative about the idea within the legislation in question. So, I'm sorry, this must seem very much like teaching you to suck eggs, but I believe it's worth saying anyway. It helps to deliberately read slowly and carefully and methodically, and I find reading out loud often helps to gain the sense. There are some general tips that I can offer about reading legislation. An Act needs to be read as a whole. It needs to be read in a way which is mindful of its purpose. So read the Act having read the long title. The long title sets the context for the whole of the rest of that primary legislation. It's a bit like understanding the plot of a novel. In my view, regulations can be read in a more targeted fashion. So scan and become familiar with the contents page. it will give you all sorts of information as well as a general overview of the lie of the land, as it were. It might, for example, show you the relevant regulator. It should paint a general picture. It's worth checking, by the way, at the date in which it was enacted, and just check that that particular piece of legislation was in force at the time of any alleged offence. You never know. If it's making amendments, sometimes it might be worth checking when they're brought into force, and rarely perhaps it might be helpful to read the original statute, the original preceding legislation. If you have, in reading a piece of legislation, any questions about meaning of words, the first thing to do is to check this interpretation section for definitions. Sometimes the word that you want won't be there, so use a dictionary. The Oxford English Dictionary is usually a good bet. There isn't a special one that lawyers use. And if you're really unable to find what you're looking for, you can check something called the Interpretation Act. All of these are available online. I still keep a copy of the Interpretation Act on my desk at home, and it's only about 20 pages long, but it's really helpful to remind yourself of the conventions that are used in writing legislation, and therefore in reading legislation. I can't emphasize strongly enough that the details are really important. If you miss a tiny detail, you could be all at sea. I'll just leave that there for a little while. There are details of interpretation, for example, in the Interpretation Act about gender and number. So in any act, unless it says something different specifically, masculine includes feminine and feminine includes masculine. Words in the singular include the plural, and words in the plural include the singular. Pay particular attention to conjunctions. Used between paragraphs and between paragraph sub-paragraphs, but they will not always have conjunctions between them if no one conjunction is suitable or because none is readed. Conjunctions are and, but, and if. So these can be tricky. So read them and reread them. If things are getting too heavy or getting serious, please ask a lawyer. They're the experts. They're the professionals. In ordinary life, different words mean different things to different people, and much of the time that doesn't really matter too much. Relationships usually survive miscommunications. Meeting actions generally get recorded and may or may not be completed for a variety of reasons. And individual differences of interpretation only occasionally matter. But with legislation, primary or secondary, the details are important. You need to be aware of the context, what the legislation is about, and you need to be mindful of the definitions provided within the interpretation sections. So, are these things important to radiation protection? Well, yes, they are. They become relevant when thinking about things like mobile radioactive sources. What is the definition of a mobile radioactive source? They're important when it comes to things like invoicing for fees and charges, permits, permitted limits, and record keeping. So it's important that you understand the terms used, and they won't always be defined in the legislation. I'm been looking this morning at Pete Cole's list of things to talk about again, and I haven't been able to address all the interesting terms that he suggested. But part of the reason that I've chosen not to is that many of them you won't actually encounter in the radiation protection arena. So I've just not addressed them. Sorry, Pete. I will, though, do two other things before I finish. First, I'd like to look at the word permission, and secondly, I'll set you some homework. Permission is one of those words that we use a lot these days, and it's important to realise that the Oxford English Dictionary definition includes two different slightly different definitions. One is the action of officially allowing someone to do a particular thing, a consent or an authorization. And it's also, the definition is also an official document giving permission. So a permit is a document which is a form of permission, for example, to keep and use radioactive substances. In some contexts, a permission may be called a consent. The word permit or consent are broadly synonymous, and also synonymous, by the way, with the IEA terms of notification, license and authorization. Permissions can be revoked or withdrawn or cancelled. There isn't actually a consistent use of the term revocation. Laws are repealed. Registrations and consents may be revoked or cancelled. So there is a limit to the consistency which even lawmakers can achieve. Now, before I finish, I'd like to suggest a bit of homework to give you an opportunity to practice some of these things. I can't give you all the secrets, I don't have them myself, but the biggest thing I can recommend is that you practice and become familiar with the landscape of the legislation that's relevant to you. So what I would like to suggest is, if you go away from this webinar with the intention of taking it further, look, probably again for most people, but look at the concepts of exclusion, exemption and clearance. Explain these ideas to yourself in writing. Write it down, then read it out aloud and check it makes sense to you. Then I would invite you to write a short reflection on what you've done and add this to your professional portfolio. So to conclude, this has been an updated but very cut down version of what I taught for 5 years at Cumbria University. It's a challenging subject because it is pretty dry, to be honest, but if one is interested in these things, and I think you should be, certainly could be, then the challenge is to know what to leave out for someone in my position today. I could have included so much more material, but my justification for not giving you more is I had a severe time constraint. As professionals, you're more than able to go forward from today and develop yourselves, and I need to save my time for sailing while the season still lasts. So, as far as further reading is concerned, I would recommend 2 titles. The first one is a paperback called The Rule of Law by a chap called Tom Bingham, who used to be, he's dead now unfortunately, the most senior judge in the country, the Right Honourable Lord Bingham of Cornhill. This book is about £8 from Amazon. It's a really good read. I think every A-level student in the country should read it. It's part of citizenship. If you're wanting something a bit more scholarly, then I would suggest something called A Practical Guide to Statutory Interpretation by Lowe and Potter and Hart Publishing. That's about £60 in legal bookshops, and it is for the more enthusiastic people. Now, there are so many things we could have talked about, and I'm sure you'll feel there were things that I should have talked about, but it's such a big area. But what I would really urge you to do is to spend some time becoming familiar with the legislation, the landscape, the lie of the land of things that you use on a day-to-day basis, because it will help you at work. It's a professional skill. It's certainly something that should be there at chartered status. I don't think I have anything more to say, so thank you for listening.